So next case is Pakala Narayan Swami versus Emperor AIR 1939 PC 47. So Pakala Narayan Swami case was about confession, and confession is not defined in Indian Evidence Act, and the definition comes from this case only, which defined confession as that confession must admit the offense or essential facts that constitute the offense, which incriminates the offender. Either he should admit the offense directly, or he should state about the incriminating facts which constitute the offense. So these are the two parameters of confession as given by the Privy Council in Pakala Narayan Swami case. And so the case is known for its interpretation of the concept of confession and its admissibility as evidence. So what happened in the case was, let's go briefly about the facts. What happened in the case was, there was a lifeless body, dead body of a person named Indian national Curie Nakaraju, and his body was discovered in a steel trunk, dead body, in a third class compartment at Puri. The trunk had been left unclaimed, and the gruesome discovery of the body had been dismembered into 7 portions, and the medical evidence unequivocally pointed to the murder. Now, during the investigation stage, as the investigation went on and at the accused residence also the police visited, a statement was given to the police by the accused, and he claimed that accused said that deceased had visited his house on 21st March, and he spent the night and in the outer house, and departed on the evening of March 22nd. The very next day he departed by a passenger train. Now, the defense objected to the admission of this statement, yet it was accepted by the lower courts. This was the contested statement. What happened was, he stayed here, he came and he stayed in the outer house, and then he left. Now, this was the statement made, and this was the contested statement, and the accused objected to the admission of this statement. Accused means defense objected, but it was accepted by the lower courts. And apart from this statement, there was substantial evidence which indicated that, there were other evidence also which was present, that the accused had ordered a trunk which was delivered to his house on March 22, and on March 23, same trunk now containing the deceased body was placed on a train at the Berhampur station. Now, widow of the deceased, the person who had died, his wife, has also stated that her husband had informed her of his intention to travel to Berhampur. He claimed to have received a communication from the accused wife instructing the deceased to collect the payment of his dues. Now, the session judge the session judge of Berhampur convicted the appellant of murder, imposed a death sentence, and the High Court also on appeal affirmed the conviction. Now, appellant sought recourse to the Privy Council, appealing by special leave. He made a special leave to a Privy Council. Now, the issues which were raised in the case were whether, number one issue, whether the statement made by the accused can be construed as confession. Second, whether the deceased statement to his wife indicating his intention to travel to Berhampur to retrieve a loan qualify as a dying declaration. Right? What were the two issues? Whether the statement जो accused ने statement किया है, क्या उसको confession आप कहोगे कि वो यहाँ पे आया था and all the stuff. And the second चीज was, क्या जो deceased ने statement किया था अपने wife को कि मैं पैसे लेने उनके घर पे जा रहा हूँ, क्या वो एक डाइंग डिक्लेरेशन बनेगी? नाउ यहाँ पे अक्यूज्ड का, एपेलेंट का कंटेंशंस क्या था कि द स्टेटमेंट ऑफ द विडो दैट हर हस्बैंड मेंशन्ड गोइंग टू बरहमपुर टू कलेक्ट मनी एज relied on March 20 cannot be admitted as evidence. ठीक है, कि उसने अपनी वाइफ को बोला था कि मैं बरहमपुर जा रहा हूँ, उसको हम एविडेंस में नहीं ले सकते हैं, दैट कैनॉट बी एडमिटेड. ये डिफेंस का कंटेंशन था. It does not meet the criteria of a dying declaration under section 32 of Indian evidence, as it neither pertains to death nor decides or indicates the circumstances leading to death. Second, statements made by accused to the police before arrest cannot be admitted under 162 CRPC, as the term any person encompasses the accused also. Any person is broadly interpreted here to include the accused also. Therefore, the statements made by an accused to the police during an investigation, what 162 states, that the statement is made by the accused to the police during an investigation, if not reduced to writing and signed, cannot be used as evidence, right? So 162 has a broader domain, and that we will be discussing later. So what happened in this case was like accused had made the statement to the police before investigation, right? Now the statements made by the appellant accused to the police during custody, third issue which was raised by the defense here is statements made by the appellant accused to the police during custody do not qualify as a confession under section 25 Evidence Act and are therefore inadmissible. Now what were the contentions of the respondent? That wise statement considered as dying declaration under section 32 of Indian Evidence Act are admissible because they were made in the circumstances leading to the deceased's journey to Berhampur, where he met his demise. Now, next point, statements made by the accused do not fall within the purview of section 162. This was a assertion of respondent, contention of respondent, that statements made by the accused do not fall within the purview of section 162. Third, the confession of appellant accused is admissible since it was made before the arrest. So there would be no bar of section 25 as the confession was made before the arrest. There was no police custody and he was not under any control of the police. Fourth was the discovery of clothes with blood spots is admissible under section 27 of Indian Evidence Act. Now the judgment given by Privy Council in the case Pakala Narayan Swami versus Skin Gang Prayer was, the Privy Council rendered its opinion asserting that statement provided by the accused, which was given by him to the police, was a mixture of confession and an attempt to explain his innocence. In light of granting benefit of doubt, Privy Council held the accused's conviction, elucidating the following observations. What were the observations made by the Privy Council? Now, Privy Council held that the term confession can be derived from an accused statement implying the inference that he committed the crime. Now, there is a statement made by the accused which implies the inference that he committed the crime. Number 2, a confession by definition either expressly admits to the offense or substantially admits all the facts constituting the offense, right? Either you are admitting it directly or constituting all the facts. You are narrating all the facts, which we can have an inference that it was confession. Third point was an admission of gravely incriminating fact, even if not conclusively incriminating, cannot be classified as a confession. Now there is a chain of circumstantial evidence which we have to establish that points out to the hypothesis that points to the guilt of the accused, that which bypasses the presumption of innocence against the accused, which means that if we are going to establish the circumstantial evidence chain, the evidence should be conclusively point towards the guilt of the accused, that there is not a single chance or a benefit of doubt that the accused has not committed the offense, right? So all the gravely incriminating facts, if conclusively proved, that admission can be classified as confession, right? But that has to pass the test of all the parameters which were laid down in Sharad Birji Chand Sharda case, right? Now what was held in this case, that an admission of a gravely incriminating fact, even if not conclusively incriminating, cannot be classified as a confession. Matlab the facts which you are stating must be conclusively incriminating. First, the facts are incriminating, and secondly, there should be conclusively pointing towards the guilt of the accused, and there is no benefit of doubt and there is no exception to that. Now fourth point is, a statement containing self-explanatory matter cannot qualify as a confession if you are absolving yourself from the guilt. It must either be accepted in its entirety or rejected, because it's a question of liberty and the conviction. Like, you will have to be incriminating against a sentence like 5, 10, 15 years or whatsoever, or life imprisonment. So confession has to be seen, like cautious approach to be seen. Now, fifth point is that statement of deceased to his wife was recognized as dying declaration as and deemed admissible under section 32 subsection 1. Now, Privy Council held, let's point towards a conclusion. What Privy Council held, that statement obtained by the police from accused before the arrest was improperly admitted into evidence due to 162 CRPC. Right? However, despite rejection of statement, the presence of the deceased at the accused house, the sole purpose the statement sought to establish was sufficiently proved by other evidence. Statement made by the deceased regarding his journey to the accused residence and to meet the accused wife residing in accused house was rightfully admitted. This was considered a statement about himself of the circumstances leading to the transaction that culminated in his death, falling within the purview of subsection 1 of section 32 of Indian Evidence Act. So, while court rejected the statement, other evidence was deemed sufficient to sustain the conviction for murder. So 32 1 parameter was satisfied, and he was held convicted for murder. Now, this judgment gives the definition of confession as to what constitutes the confession into two parameters, and the broad and proper admissibility of statements that comes under police investigation. And the next thing was like it gave the broader perspective to dying declarations as an exception to hearsay rule, and like a person explained the circumstances as to the cause of his death, and resultantly that would come under the purview of DD. And the statements made before the arrest without proper caution under 162 CRPC, it stressed the exclusion of such statements.